Should my trademark application be filed based on use or intent to use? In the US, in order to obtain a trademark registration, you have to use that mark in connection with the goods or services that you file your trademark application for. However, you can file what's called an intent to use application, which basically means that you have a good faith basis that you're going to use this trademark in the future in connection with the goods or services that you file for. The only exception to this is if you're a foreign entity and you're basing your application off a foreign registration, then you don't have to show use. Okay, so what is use in commerce and what is not use in commerce? So you'll see when you're going to file an application, one of the things you have to do is list out the goods or services you're filing for. And you would do that here on this page. If you're doing it yourself, just put in, so here I'll put in legal services as an example. And just click legal there. And what happens is when you go to insert checked entries, it's going to ask you what's the filing basis. In most cases, it's going to be 1A or 1B. 44D and 44E are based off of foreign applications or foreign registrations when you're trying to claim a priority date or claim priority from one of those. So for 1A, what's going to happen is that's the use-based application. You're then going to have to upload a specimen and show how you're actually using it in commerce. But what is use in commerce? If the PTO website's having an issue there. What is use in commerce? Use in commerce means that you're actually using the trademark you file for in connection with the products or services you file for. And it's going to be, depending on how you list it, everything you list for. So a common mistake I see is that someone within a class will list out, especially for clothing, they'll put tops, bottoms, ties, jackets, but maybe they're not using it on the ties or the jackets. They just have tops and bottoms or vice versa. That's not used on all of those goods. So you have to be very careful that when you do list your products, it's only the products that you're actually using it on if you're filing a use-based application. If you're filing intent to use, then go ahead, put everything in there, but you might need to delete some of that out at a later date. So use in commerce means that you're actually selling the goods. That means the products have to be here in the US and available for sale for a customer. And on it or on the packaging has to have the exact trademark that you filed for. If it's not exact, that could be an issue for a separate discussion. But just because the product may be being made or you have the design, or even if you just have a prototype of it, that's not enough for use in commerce. For services, it's a little more complex because services, what that means is you also have to have something that shows what are the services you're providing. Usually the best specimen is a website, but sometimes it could be like a informational one-pager about your company and the services you provide, and then a way to contact you to hire your services. Whereas, the website usually has a place to call or sometimes even to buy the service directly from the website, and they're going to want to see that. And having that along with actually providing the service is what constitutes use in commerce for a service. So, here is just some examples for goods that I just wanted to show you from the U.S. Patent and Trademark Office, which shows you how all these different, labels on the bottom, label on the handle, label on the website, and then, packaging. It could also be on the packaging of the goods that shows the labels. Sometimes it could be where they're being sold. So I'll put this link in the bottom because it just shows some things, Here's the website. Services, as I said, are sometimes a little more complex. Online is generally the best place to show. That makes it the easiest. But other materials could provide that as well. It's just a little harder. It is possible for a business card. You'll see down here, because I know a lot of clients come to us and have just a business card. But you're going to need that business card to also usually have some indication of what the services are that you're providing in a little more detail. Same thing with invoices or any other material to promote the brand, signages or other marketing material. There has to be an association between the brand and the services you're providing, and usually some way for a customer or potential client to actually then hire you. So what is not use in commerce? Just because you formed an entity, that does not mean you have use in commerce if you do not have everything else we just spoke of. Same thing for if you got a domain name and don't have anything on it. If you're not providing the service or if you're not selling the product, you still don't have use. So that's some of the most common ways that people ask, or as I said, if we're putting it just on a prototype that's not yet available for sale is not enough. Just sending an invoice usually would not be enough for use in commerce without, some more of a description like it showed down there. So just a few things. It's really important to get this right. However, it is possible to amend it, but it's really more important that if you're filing use-based, you actually are using it on everything you say you're using it on. And even though you don't have to upload a specimen for every single thing, it's good to maintain that for part of your records. So any questions, you can always feel free to reach out to us at 888-666-0062, or you can email us at office@jhrlegal.com. Thanks.